Hilchos Mloa Veleva, Chapter 16. 1. Debt is the responsibility of the borrower until he pays the lender or the lender's agent. If the lender says, throw the money owed to me and become free of responsibility, the borrower threw it to him and it became lost or destroyed by fire before it reaches the lender. The borrower is not responsible. The following rules apply. If the lender told him, throw the money owed to me in a manner governed by the laws of a bill of divorce, if the money was closer to the borrower, it's still on his responsibility. If it was closer to the lender, the borrower is no longer responsible for his half and half, and it is lost and stolen. From there, the borrower is required to pay half of the debt. 2. When Reuven owes Shimon a money and gives the money to Levi and tells him, give this money that I owe Shimon to him, Reuven may not retract. Nevertheless, he is held responsible for the money until it reaches Shimon. If Levi return the money to Reuven, they are both responsible for it until Shimon receives full payment for the debt owed him. 3. A transfer of debt is rescinded in the following situation. Reuven owed Shimon a money. Shimon told Reuven, take the money that you owed me and give it to Levi. Since the three were standing together, Levi agreed the transfer would ordinarily be binding. Nevertheless, if it is discovered that Reuven is poor, does not have the resources to pay, Levi can ask Shimon for payment of the debt, for he deceived him. So if he knew that Reuven was poor at the time Reuven was rich, at the time he became impoverished, afterwards he cannot demand payment from Shimon for he accepted the transfer. If Levi argues Reuven was poor at the time Shimon deceived him, Shimon maintains that he was wealthy and later became impoverished, it appears to me that Shimon must bring proof of his claim. Only then is he free of responsibility from the debt he owes Levi. This is no different from an instance where he has a receipt in his hand. Every time prove the authenticity of your receipt, and then you will be free of responsibility for. We have already explained the following concept in the laws of business transactions. These laws apply when Reuven was not owed anything by Shimon, but did owe money to Levi. If he told Levi to collect the debt from Shimon, even if he made that statement in the presence of the three of them, it is not binding. If Shimon does not desire to pay Levi, he need not. If however he does pay him, he may collect the money from Reuven, since he paid him because of his instructions. Similarly, if Levi desires to retract and say I do not desire to collect the debt from Shimon, he may collect the debt from Reuven. This applies even if he collected a debt. If he collected a portion of the debt from Shimon, he may collect the remainder from Reuven. 5. The following also apply with regard to a storekeeper who would give a house owner anything he desires on credit, postponing payment until the entire amount, which is a substantial sum, at which time he would pay him. The employer says, give my workers his other, or my creditor the money that I owe you and I will pay you afterwards. The storekeeper said, I gave the money you instructed me to give, and the worker or creditor says, I did not receive the worker. The creditor must take an oath. He may then collect the debt owed him from the employer. Similarly, the storekeeper may take an oath and collect what he claimed from the employer, for he told him to pay that money. The worker must take an oath in the presence of the storekeeper, and the storekeeper must do so in the presence of the worker or the creditor, so that they will be embarrassed by each other. Similar supply in analogous situations, as oaths or rabbinical ordinance is administered while the person holds a sacred article, because both claimants are coming to collect money. Therefore, if the storekeeper dies, the creditor may collect the debt without taking an oath. Similarly, if the worker or the creditor dies, the storekeeper may collect the claim he makes without taking an oath. The rationale is that in such a situation, the employer is not losing anything and is making payment only once. 6. When the storekeeper says, you told me to give this person a money, or you commanded me and told me if so-and-so comes, give him, and the employer claims I did not tell you, the employer must take Shavuos has to support his claim. He is then free responsibility. The storekeeper should then lodge a suit against the person he claims to have paid. Similarly, if a storekeeper tells an employer with whom he has credit arrangement, it is written in my account book that you owe me a month. The employer says, I don't know. The employer must take Shavuos has that he does not know. He is then free responsibility. As the law with regard to any situation where one person lodges a claim against another, there is no rabbinical ordinance governing such a situation. 7. When Reuven produces a promissory note that says Shimon owes the debt to Levi and claims that Levi gave it to him by signing a deed acknowledging the transfer and giving it to him, but that the deed transfer was lost, or claims that Levi transferred the promissory note to him via the acquisition of land, and may collect debt from Shimon. The rationale is that Reuven is in possession of the promissory note. Shimon claims that he paid Levi, and the man that must be taken. Levi must take an oath to Shimon. Afterwards, Reuven may collect the debt. If Levi admits that Shimon paid him, Levi must pay Reuven. If Levi claims that neither sold nor gave the promissory note to Reuven, Levi is required to take Shavuos Hesed and is then free of responsibility. 8. When a promissory note is in the hands of a third party, he produces it in a court of law and says it has been paid. His word is accepted, even if the authenticity of the note has been verified. The rationale is that if he desired, he could have burned it or torn it. Similarly, if the third party died and note is found that his possession is in, the promissory note trust him has been paid because they were paid. Even if the note stating the debt was paid, it's not found by witnesses. When by contrast, the note is found, the creditor's possession whether a particular promissory note has been paid, even if the note stating the debt was paid is in the creditor's handwriting, is considered to be merely facetious. 9. If witnesses sign a note discovered in the creditor's possession when their signatures have been verified, the note is considered paid. If the signatures have not been verified, the witnesses who signed the receipt should be interrogated to not know the matter, or they are not present to be asked. The receipt is ignored because it is found in possession of the lender or his heirs. 10. If the promissory note mentioned in the note was discovered and was found among the promissory notes belonging to the lender that have been paid, we assume that it was paid, even if the note was found not signed by the witness. Similarly, if it is written on the promissory note itself, whether when it's front or it's back, or only a portion of it, the promissory note or the portion of it was paid, we follow these statements and suppose even though the witnesses did not sign the statement, the promissory note is in the possession of the lender. For if the promissory note had not been paid, we would not have written on the note itself. 11. When the person finds a promissory note amongst other legal documents and does not know its status, it should remain in his possession until Eliyahu comes. 12. When a person tells his sons, one of the promissory notes among my promissory notes has been paid and I do not know which one it is, all the promissory notes are considered paid. If there was 2 promissory notes from one person, the greater one is considered paid, the lesser one is considered unpaid. If a person tells a colleague, one of your promissory notes in my possession has been paid, the greater one is considered to be paid and the lesser one is considered to be unpaid. If he tells them that you owe me has been paid, all the promissory notes he has against them are considered paid. Hilchos Mloa Veleva, Chapter 17. 1. The following laws apply when a lender dies and his heir comes and demands payment from a borrower because of the department store for which he is liable. If the borrower claims I paid your father and the heir says I do not know whether you did or not, tell the borrower arise and pay him. If the borrower demands take an oath from me, heirs take an oath while holding a sacred object. His father did not instruct him via another person that the debt was paid, and did not tell him this verbally, and he did not find the note saying that this promissory note was paid out among his father's legal documents. After taking the oath, he may collect the debt too. The borrower died after the lender died, and the lender's heir comes and demands payment from the borrower's heir. He may not collect the payment unless he takes an oath. We tell him to take an oath that my father did not instruct me, my father did not tell me, and did not find the note saying that this promise note was paid among father's legal documents. Even if the heir was a baby lying in a cradle when his father died, he must take this oath and collect. If the lender made a statement immediately before his death that this promissory note has not been paid, the lender's heir need not take an oath before exacting payment. This applies even if he is collecting payment from the heir. 3. If, however, the borrower died first, then the lender died, the lender's heirs may not collect anything from the borrower's heirs. The rationale is that when the borrower died, the lender became obligated to take an oath before collecting. As we have explained in the previous lacha, he has already died, and a person does not bequeath an oath to his funds. They are unable to take an oath if the father was not paid anything. Nevertheless, if a judge transgressed and required the lender's heirs take an oath and enabled them to collect their debt, the money that they collected should not be expropriated from their possession. Therefore, a promissory note that is used as the basis for a claim by the heirs of a lender who seek to collect from the heirs of a borrower when the borrower died first should not be torn, nor should it be used to expropriate money. It should not be used to expropriate money because the person does not bequeath an oath to his sons, as explained. It should not, however, be torn unless there be a judge who will expropriate money because of it. 4. In the situation described above, even if the debt was secured by a guarantor, the lender's heirs should not expropriate debt from the guarantor. The rationale is that if they are told to collect debt from the guarantor will go and seek payment from the borrower's heirs. 5. Extrapolation is not made from this law to a similar instance. Instead, when a person who impairs the legal power of a promissory note then dies, he is not entitled to collect the debt unless he takes an oath. His children may take an oath. Their father did not instruct them, their father did not tell them, they did not find a note saying that this promissory note was paid in its entirety among the father's legal documents. They may then collect the remainder of the sum stated in the promissory note from the lender or from his heirs. 6. When a lender's heirs come to collect payment of a promissory note from the borrower's heirs, and the latter say, "Our father told us I did not borrow the money mentioned in this debt," the lender's heirs may collect the debt without taking an oath. The rationale is that whenever a person says they did not borrow, it's as if he says that did not pay. Similarly, when the lender himself comes to collect payment from the heirs of a borrower, they say, "Our father told us I did not borrow the money mentioned in this debt," the lender may collect the debt without taking an oath. This applies even if in the promissory note the lender stated that he would accept borrower's word whenever he claims to have paid the debt. For in this instance, we follow the rationale whenever a person says they did not borrow, as if he says they did not pay. 7. The following laws apply when the lender's heir comes and demands payment from the borrower on the basis of a promissory note that contains stipulation that the borrower's word will be accepted. Whenever the borrower says, "I paid the debt," he is required to show his hazards that he paid the debt, and he is free of liability. This applies even if the stipulation does not say your word will be accepted against the claim issued by my heirs. The rationale is the very basis. The promissory note depends on this stipulation. If the stipulation stated the borrower's word would be accepted without an oath, he is not required to take an oath, even to the lender's heirs. 8. The following laws apply when the lender's heir is below majority. He possesses a promissory note owed to his father, but a receipt for this note was produced after the father's death. We do not report promissory note, nor do we allow payment to be expropriated on its basis until the heir reaches majority. The rationale is that it is possible the receipt is a forgery. That possibility is reinforced by the fact that the borrower did not produce it during the lender's lifetime. When a person produces a promissory note against a colleague stating that it was composed in Babylonia, he collects the debt in the coinage of Babylonia. If the promissory note was written Eretz Yisrael, you should collect that in the coinage of Eretz Yisrael. This is not the case with regard to a ksuba. The following rules apply when the promissory note did not state the place where it was composed. If the lender produced it in Babylonia, you should collect that in the coinage of Babylonia. If he produced it in Eretz Yisrael, you should collect that in the coinage of Eretz Yisrael. If the lender sought to collect that in the coinage of a place where he produced the promissory note, and the borrower protests a claim that he is obligated to pay in the coinage that is worth less than the local coinage, the lender should support his claim with an oath. He may then collect the debt. If the promissory note states that money is owed without any more specifics, the lender may collect only what the borrower agrees to pay. From these laws, we can derive the following principles. A legal document that does not mention the place where it was composed is acceptable in all matters. Similarly, a legal document that is not dated is acceptable even though it is testimony that cannot be nullified through hazama. The rationale is that in financial laws we are not stringent and do not subject the witnesses to process, cross-examination, and interrogation, as will be explained. This leniency was adopted so as not to prevent loans from being granted. For this reason, post-data promissory notes are acceptable even though the testimony of the witnesses signed it cannot be nullified through hazama, as will be explained in the appropriate place. Hilchos Mloa Veleva, Chapter 18. When a person lends money to a colleague without any stipulations, all the borrower's property is on lien and bound to the debt. Therefore, when the lender comes to collect his debt, he should demand payment from the debtor first. The debtor does not have the money, but is in possession of the lender and movable property, may collect the debt from them with the borrower's consent. If the borrower did not give the property willingly, the lender should have the property expropriated by the court. If the property in the borrower's possession was not equal to the value of the amount stated in the promissory note, the lender may expropriate the debt from all the property that was in the borrower's possession, even though it is now sold or given as presents to others. Rationale: since the borrower sold to give away the property after it was subjected to the lien of his debt, he may expropriate the property from the possession of the purchasers, the recipient of the presents. This is called being Teiveis. To what does the above apply? To land the property in the borrower's possession at the time of the loan. Property that the borrower acquired after the loan was given by contract is not automatically on lien to the creditor. He may not expropriate it from purchasers. If whoever the lender establishes the stipulation that all property that the borrower will acquire afterwards will be on lien for him to collect the debt from it, the property the borrower acquired after taking the loan and subsequently sold or gave away may be expropriated by a creditor. To the above mentioned the above statements apply only to landed property and movable property that had been sold. By contrast, is not on lien to a debt. Even property in the borrower's possession at the time of the loan may not be expropriated by his creditor. If the debtor transferred a lien to all his movable property by virtue of a lien on the land properties of the creditor can expropriate everything. He may expropriate that movable property. This applies only when he writes in the promissory note, I have transferred to you a lien on my movable property by virtue of the lien on my landed property. This is not smachta, nor is this a standard form of a legal document. Similarly, he may write all the property that I will purchase in the future, whether land property, movable property, is on lien to you, so that he can expropriate him from it, and the lien on my movable property is transferred to you by virtue of the lien on my land property, so that you can expropriate payment from them. This is not a smachta, nor is this a standard form of a legal document. So, since the creditor may expropriate even the movable property the borrower purchased after he borrowed the money, the rationale to any stipulation made concerning a financial transaction is binding. 3. The following laws apply when a person designates a field of his as an apoteki for a creditor. For a debt, or for a woman for a ksuba, i.e. composed legal documents stating that they should collect payment from that source, and a river flooded the field. The creditor may expropriate the other property as payment for the debt. If whoever was stipulated he should not derive payment from any place other than this, he should not expropriate other property. Similarly, if a person borrowed money explicitly stipulated that his property is not on lien to the debt, the creditor may never collect the debt from property that has been sold to others. 4. When a person designates a field of his as an apoteki for a creditor for a debt, for a woman for a ksuba, and then sells it, if it sales binding, if the creditor comes to collect his debt, he does not find any property that has not been sold. He may expropriate the field that has been designated from the person who purchased it when it apply when the debtor sold the field for a limited amount of time. If whoever desired to sell it forever, the sale is not binding. 5. When a person designates a servant as an apoteki, a creditor can expropriate the servant to payment of the debt even if he was sold to another person. The rationale is that the matter will be publicized. If he designates his cow as an apoteki, a creditor may not expropriate the cow. The same ruling applies with regard to other movable property, where the matter will not be publicized. 6. When the master designates his servant as an apoteki and then frees him, he obtains his freedom. But even if he wrote in a promissory note, you will not receive payment from any source about this. Similar will apply if he consecrates the servant. The rationale is that the prohibition against leaven, freeing a servant, and consecration remove the lien from an article. The creditor may collect his debt from the debtor. If he does not have the means to pay him, he must compose a promissory note acknowledging his debt, and with that promissory note he can expropriate property that was sold to the debtor after the date of the second promissory note. Why is he obligated to pay the debt? Because he caused the colleague's loss. He caused money to be lost, and whenever a person causes a colleague a loss, he must make financial restitution as to pay in the appropriate place. We also compel the servant's second master to free him as well. This is a measure inaccurate for the correction of society, lest the creditor encounter the servant in the marketplace at a later time and say, you are my slave. 7. When a person consecrates property, the creditor cannot expropriate the property from the temple treasury, for the consecration of property lifts the lien from it. When the property is redeemed from the temple treasury, we estimate how much a person would desire to give for this field, so that the creditor will be paid his due, or the woman the money due her by virtue of ksuba. Therefore, when the field is redeemed, it becomes unconsecrated property in the possession of the purchase. The creditor can come expropriate his debt from it. The woman can take it as payment for the money due her by virtue of ksuba, as we've explained. 8. When the creditor comes to expropriate a field for the purchaser, if the purchaser has money in his possession, he may limit the creditor's claim by paying him the money for which he is expropriating the field. The purchaser then demands repayment from the seller. For whoever the debtor has designated as field as an apoteki, the purchaser may not eliminate the creditor's claim by paying him. 9. The purchaser is also given the upper hand in the following situation. Reuven owed Shimon 200 zuz. Reuven owned 2 fields. He sold one to Levi for a mana and then sold him the other one for a second mana. Shimon expropriated one for a mana, then sought to expropriate the other for the second mana that was owed to him. Levi brought 200 zuz in coin and told Shimon, if you desire to consider the field that you have already expropriated as payment for the entire 200 zuz that you are owed, this is acceptable. If not, here are the 200 zuz of the debt. Rescind your claim. Levi's given the upper hand. If Shimon accepted Levi's proposition and kept the one field, Levi cannot demand payment from Reuven for more than 1 month, despite the fact that Shimon accepted his compensation with 200 zuz. 10. The creditor by contrast is given the upper hand in the following situation. Reuven owed Shimon 200 zuz. Reuven died and left one field that's worth 100 zuz. Shimon came and expropriated it. Through orphans gave Shimon 100 zuz worth of the moved property the father left and thus moved Shimon from it. Shimon may, however, return and expropriate it for the remainder of his debt. The rationale is that by giving him the 100 zuz, they performed the mitzvah for the heirs to pay the father's debt. If the heirs told Shimon this is 100 for the field you expropriated, he cannot come back and expropriate again for the remainder of the money owed him.